Does anybody still need the book? There's one box with books.
Oh, it's right.
If you don't need the book, this is a good sign, because then I assume you got it, you have done the readings, and then you're prepared for this class. That is lovely. And if you haven't, you will see, well, a bit difficult to follow if you haven't done the readings. We will see that. Okay, it's 10:15. Welcome to our first class where we make you work. We do case study number 1. We do it, as I told you last week, we do it slowly, smoothly, and then so next week we will still work with case study 1. So for a reading for next week, just finish the reading of case study 1. If you want to come closer, I need my binoculars. Yeah, okay. So if ever from next week onwards, just move a little bit closer, because you're very far away. It's a large classroom. Yes, so we will start with case study 1. We will work with case study 1 today, very slowly. And if ever you have a question, raise your hands, tell me could you please repeat? Could you please answer to this or that? I was wondering if, and so on and so forth. So, and next week we will finish case study 1 slowly. And then from the week thereafter, then we will speed up. Then we will do one entire case study per week. So the rhythm will be a bit faster, but this is absolutely doable. So you saw the scenario. We have already introduced it last week. Computers displayed in a shop window, advertised in promotional material, and a newspaper advertisement where a job is offered. So the first question is, did the salesperson make a valid offer by displaying the computer in the shop window, by advertising the computer in the promotional material, or advertising the job in the newspaper? So who made the offer? And then the question is, has the contract been formed? If the salesperson by these acts made an offer, then it is sufficient that the customer declares acceptance and the contract is formed. If all these acts by the salespersons are merely invitations to treat, the invitations to make an offer to the customer, then it is the customer who makes the offer. The salesperson has still the option to say no, and no contract is formed. That's the difference. When considering my case scenarios, you saw we have 10 case scenarios. So it's a limited number of topics, and I discussed it with practitioners. So that, from your practical point of view, you look back at your work. Is that a case that is relevant? Is that a case to start with? And the answer was mostly yes. This is fundamental. This keeps us thinking. So yes. So it's close to practical needs. And yeah, you saw the table of contents. You see the jurisdictions, and then you have started reading. So the first jurisdiction, you saw the introductions. You probably felt that doing it all the introductions for the first reading is probably a bit too much. You can do that later or whenever convenient. But it's good to read these introductions to feel more comfortable with these jurisdictions, and in particularly the introduction to English law. It's just a couple of pages, but you get some quintessentials about these jurisdictions. There are also introductions, larger, more, of course, longer, more detailed introductions to all these jurisdictions. The most successful book ever, an introduction to comparative law, was written by Konrad Zweigert and Hein Kötz. It's available in English, in German, and many other languages, but not in French. So if you want to know much more, you can go to these books. What I put in here is basically, yes, the key information, the absolutely basic key information. So our first jurisdiction this week is English law. The reason is it's an English publisher. So, okay, so first case, then you start with English law. They didn't require that, of course. But yes, High Court, Queen's Bench Division, Fisher and Bell. A case from 1960, one Queen's Bench Division. This is the official report. Or there's another faster report that we have in the library as well, the All England reports. So we give you a case and not a statute and not provisions from a civil code. Why?
Because the English legal system works with precedents.
Yes.
Rather than statutes.
Yes. Because there is no English civil code. There were proposals in the 19th century, 18th, 19th century to draft a civil code following what was going on the continent, but the English already had a case law system, and the lawyers defended. We are managing the law. We are the judges, former lawyers, the lawyers, practitioners. The law is in our hands. We don't need a civil code. We don't need a civil code. We go on with our case law system. So contract law remain. They have statutes in England, of course, in the UK for specific topics, more in administrative law than in general private law issues, and we will see some of them as we go on in this class. But contract law remains largely uncodified case law. So you get a precedent and a case that gives us answers to our questions. Yeah. And so it is a High Court decision. This is a court of first instance. It's a court in central London, High Court, with 3 divisions. One was Queen's Bench Division, now is England has a king. King's Bench now, King's Bench Division now, and it's a court of first instance. Second instance is the Court of Appeal, and then we had the House of Lords in its judicial capacity. That is, there were some members of the House of Lords that had a judicial capacity that were basically the Supreme Court for England and Wales. And since 2009 or 10, Tony Blair reformed this system, and it's the same persons. They moved to the other side of the road into another building, and it is called the Supreme Court for England and Wales. So that is basically it. So it's a court decision of first instance. Queen's Bench, you see the names of the justices, Chief Justice Lord Parker. When we move onward to French law, you see that you don't see the names of the judges. It's a very, very different style. So basically, when we do comparative law, it's also about styles, differences in styles, and they couldn't be larger than this English decision on the one hand and the French decision on the other, that we will read later together. So what did, I told you we do smoothly, slowly. What happened in this first case? In fact, it's not really a core contract law case, but they mention the contract law rule here because there is no contract law case on that issue. It's just so obvious to English lawyers that they state here what the general contract rule is in this case. In fact, there was a shop window And the judge tells you the short facts are these. The respondent keeps a retail shop in Bristol. Police constable walking past the shop saw in the window, amongst other articles, one of these flick knives. You press a button and the flame comes out, and these knives are considered very dangerous. Unfortunately, it's again a problem in London. There is a lot of crime in London if you walk through London in certain areas at night. Better don't, because there is again, you see the footnotes, we have added this. Unfortunately, it's again an issue. So these, it is prohibited by, it was prohibited by an administrative law statute to sell these. What in fact was prohibited: any person who manufactures, sells, or hires, or offers for sale any knife, a flick knife, shall be guilty of an offense. So the question was, a shopkeeper exposed these knives in his shop window. A police officer, when spy walks into the shop and says, well, you shouldn't do this. This is a flick knife, and so on and so forth. And the shopkeeper replied, okay, fair enough. It's more detailed. If you want more details, just ask what was the weather on that day. So you get basically everything. Then the judge tells you, in fact, the sole question is, was this statute violated here? And on what depends that was the sole question is whether the exhibition of that knife in the window with a ticket constituted an offer for sale within that statute. Did it? Did it? No, it didn't. And you learn, the judge tells you his thoughts, well, very openly. And this is why these English judgments are, for comparative law purposes, so interesting. He tells you how he got to his decision, and what were these considerations, the arguments, and so on and so forth in these two decisions that you gave you, and very openly and frankly. So I don't read you every decision in class, because then you say, why should I have read it? But it's just the warmer. That's our first case. So, and then here the judge tells you, I think that most lay people would be inclined to the view that, as indeed I was myself when I first read these papers, that if a knife were displayed in a window like this, that with a price attached to it, it was nonsense to say that that was not that was not offering it for sale. Nonsense that it was not offering it for sale. That is very, very strong words. But then he continues, the knife is there inviting people to buy it. In ordinary language, it is for sale. Okay, that's his starter. Well, layperson's ordinary language, it is for sale. But any statute must be looked at in the light of the general law of the country. For Parliament, who enacted this statute, must be taken to know the general law. And then he comes in that it is clear that according to the ordinary law of contract, and here's the information that we are looking for, the ordinary law of contract, it is clear, we know, we don't need a precedent, we all know, the display of an article with a price on it in a shop window is merely an invitation to treat. It is in no sense an offer for sale, for acceptance of which constitutes a contract. That is clearly the general law of the country. So, that is the general contract law. And then he comes to, he goes to case law. Is that okay? When I go to the general law of the country, well, we know it's not an offer. And then he goes yes. In many statutes, it's common when so desired, and so on and so forth, to insert the words offering, exposing, and so on, the legislator could have done it, but in our case, he hasn't. And then he again tells you, well, his thoughts and the development of his mind. In those circumstances, I, for my part, though I confess reluctantly, am driven to the conclusion that no offense was committed here. The flick knife was not offered in a technical legal sense. At first, it appears absurd that knives of this sort may not be manufactured, they may not be sold, they may not be hired, they may not be lent, they may not be given, but apparently they can be displayed in shop windows. But even if this is a casus omissus, and I'm not saying that it is not for this court to apply the omission. And then he goes, well, what would we on the continent probably have done in that case? What would we have done in this case? What kind of interpretation may we have considered? Yes, maybe the teleological interpretation, grammatical interpretation, historic interpretation, and then purposive interpretation. What is the telos? What is the purpose of this criminal law? And just as the judge tells you, the purpose is these knives shall not be sold. And if you put it, they shall not be offered, they shall not be sold. And if you put them in your shop window, you're as close as you can get to sell them. So that should not be. And the judge tells you, well, I see that should not be. So if you interpret this statute looking for its purpose, you reach the conclusion, well, the statute has been violated. But then the judge says, well, there's previous cases, so he goes to previous cases. I'm mindful of the strong word of Lord Simmons in a previous case. In that case, one of the Lord Justices in the Court of Appeal, a higher court, in effect said that the court, having discovered and the supposed intention of Parliament, must proceed to fill in the gaps. What the legislator has not written, the court must write. So that is what you suggested us to consider. Look for the purpose of this statute, say, well, it's a casus omissus. They could have put in exposed for sale, but it's clear that the legislator didn't want this to happen. And then he goes on and says, in answer to this contention, Lord Simmons, in that same case, in his speech said, quote, it appears to me to be a naked usurpation of the legislative function under the thin disguise of interpretation. He says, no, we are interpreting these statutes, we are not doing the work of the legislator. He hasn't done it. So, no. And this is why this case is so famous in English law. If you study, there is at school in your last years, you can do economics, or you can take law in introduction, and so on and so forth. And in the course material even for school children, you find this case, because they show you how does the English legal system work, how do courts reason. And they say, this is the function of the legislator, this is the function of the courts, and they don't fill the gaps. And that is why in English law, statutes are extremely detailed. If the legislator didn't write the word, the court will not do it for him. And then this very reluctant attitude, you may say, well, this is a criminal law case. We don't do that in criminal law very much either. True. But this is the general attitude in English law towards statutory interpretation. Very reluctant, because since the start of the English legal system in the 13th century, in the courts in Westminster, the law was in the hands of practitioners, lawyers, judges. And when the legislator acts, traditionally this is seen as an interference with the activities of the practitioners. So they say, okay, they interfere into our business, so if they interfere, if they want to say something, they have to be precise. If they aren't, we don't do their work. We continue with our case law. Okay? So this is what this case shows and what this case is also famous for. So what is the work of judges? Decide cases. So they have worked with the statute. They say we don't do the. So now we turn to case law, and that's what's happened. What happens next in this decision? They go to the case Keating and Horwood. By the way, in English law it is Keating and Horwood. In US law it would be Keating versus Horwood. It's a bit more fight the attitude in the US. Keating and Horwood in English, Keating versus Horwood in the US. So what happened there? The judge tells you a baker's van was driven on its rounds. There was bread in it that had been ordered and bread in it that was for sale, and it was found that bread was underweight. Again, an administrative statute was violated, the sale of food order. And Law2 said, and the question was, again, that order was an order of the sort to which I have referred already, which prohibited the offering or exposing for sale. In giving his judgment, Law2, Chief Justice, said, quote, the question is whether on the facts there was an offering and to an exposure for sale. In my opinion, there were both. Every justice agreed. Sherman justice didn't. Sherman justice said, well, there was an exposure of sale, but not offering. Now my question to you. This is a court decision, and English courts consider themselves bound by previous court decisions. So you have a previous court decision. You have a situation where goods were put somewhere, not in a shop window, in this case on a van, for sale. And you have two judges, you have a majority of two judges out of three who decide that was offering, that was exposing them for sale, statute violated, and it was also offering them for sale, statute violated. Why is our court not bound by this decision? Why does that not bind our court here? So again, the English rule is if a court has, if you don't have a civil code, if you don't have basic contract law legislation, then you have court decisions instead. And to make the system foreseeable, the English created the rule of stare decisis. We consider ourselves bound by previous court decisions. So if they have decided an issue, then we are bound. So my question, haven't they decided this here? Isn't that the answer?
I guess here the court is distinguishing the case by saying that the situation is not exactly the same as in the precedent.
Okay. First thing is distinguishing facts. The courts have the option to say, well, that's a different situation. We distinguish, it's different facts. We are not bound. The decision doesn't apply to our facts. That is one option, to distinguish the facts, and then you are out of the binding effect. That is one option. Okay, what is the other option?
It seems like they're distinguishing the statute. The statute doesn't just say it's prohibiting offers, but it's also prohibiting exposure.
Yes, they distinguish this, and in that way they distinguish, they make a difference. It's a different statute. The statute does exactly what our statute doesn't. The statute prohibits not only offering, but also exposing for sale. That's the difference. Exposing for sale, and there was clearly an exposure for sale. So what do you do with the holding of the majority of judges that said at the same time there was offering? Yes, it would have been enough to say there was a statute prohibited exposing the goods. That's it. End of the story. But the judges say more. They say, well, that was also offering. Didn't they decide this then with binding force for such judges in subsequent cases? Well, did you want to answer that?
Yeah, I think it's because this ruling only applies to this specific statute then. Wording is different in our case, then it's not applicable to this.
Yeah, that is trying to distinguish. But then you distinguish, you say, well, something is put, you say it was not in a shop window, it was on a van, the statute says something different, and then you try to distinguish. I'm not sure that this is the reason why our court doesn't feel itself bound by it, yes? Yes, that's the key. What is binding for the judges? So the previous case, you have this previous case, you have this decision, and you have the argument of the court that carries the decision. That is the argument exposing for sale was prohibited. This is the ratio decidendi. Why have they violated the statute? Because they exposed it for sale, and hereby they have already violated the statute. And then they say they also violated the statute because at the same time they offered it for sale. So here's another argument. But this was not important. That they didn't need it to say that to carry the decision. So this is obiter dictum. This is obiter dictum only. And obiter dictum doesn't bind the judge, the subsequent court. This is obiter dictum. This is ratio decidendi, and this is obiter. So this is just judges talking with no effect on subsequent cases. Okay, so that's basically it. And here we are. So we have a 3-0 decision where the judges say, well, exposing goods in shop windows, we know the general law of the land is not an offer. It's just an exposure, and that's it. So next English case. So we can we'll remember in English law putting things in shop windows or on vans or wherever, even if every information is given on the product, with it, including the price, that is still an invitation to treat. It's not an offer. Next case, High Court Queen's Bench Division again, Pharmaceutical Society of Great Britain and Boots Chemists. So the first case teaches us something about English legal reasoning. The second case, you will find lots of arguments on our case, on our question. So you saw the facts, and the question is, in a self-service system that was new at the time, the case in the 50s, they introduced self-service systems. You have the goods exposed on shelves, customer grab them, put them in a trolley, carry them to the cash desk, and pay. So the question was, again, there was a statute requiring that drugs are sold under the supervision of a pharmacist. And the pharmacist was placed at the cash desk. So the question was, when was the contract formed? When were the goods sold? Were they sold when the customer grabbed them, put them in the trolley? Or were they sold only, was it the customer who made the offer by putting them at the cash desk where the pharmacist stood. In the latter case, no violation of the statute. That was the question. So, what does the court decide and what are the arguments? Yes? Yes. Yes. Okay, great. The advantage of you sitting in the very back is everybody heard you, except possibly me. I'm the farthest away. So next time, move a bit closer, please. If I will call upon people, I will prefer to call them in front, because you're closer, I hear better. So if you consider participating, move to the front, please, in the future. I don't call upon you if you don't want to speak. So yes, but we heard you. You said yes. The court decided can't be. Exposure of goods in a shop can't be an offer because impossible, because would be unreasonable. It is the customer who takes the who carries it to the cash desk, who puts it in front of the salesperson, and then that is him who makes the offer to buy, and the salesperson accepting this. And you mentioned one of the reasons the court gives. One of the reasons is otherwise the property would pass too fast. Because under English law, in general, we will do this in another case later this semester, what is the impact of the sales contract on the property of the sold item? When does the property pass and under which conditions? And in English law, the property passes in principle once the sales contract is formed. So one of the reasons of the judges is, well, that's impractical. If the customer puts the accepts by taking the goods, putting in the trolley, then he becomes owner, and he could simply go to the cash desk and say, well, it's mine, buy then. It's already mine, even if he doesn't pay. That would be impractical. What else? Which are the other arguments of the judge? Yes?
It's kind of the same argument, but the person buying the whatever wouldn't be able to change his mind.
Exactly.
And that way the salesperson could insist in the offer he displayed.
Yes. So the next argument, very close, is the customer couldn't change her mind. Puts the thing in the trolley, has bought it, it's hers, and then she said, well, oh, I see, I haven't got enough money, but I urgently need this, so I put it back. Wouldn't be possible because it's hers. That is impractical. What else? Well, one argument was the pharmacist at the cash desk, so the salesperson didn't want to sell before that. That is very particular. But these two arguments are of general character, yes. What else? There's one more argument in here. That is an argument you probably know from your home jurisdictions. All those who study in Germany certainly have heard this argument. Why can't the exposure be an offer? One of the arguments is, yes? The stock may be limited. Well, then you may say, well, I see it. I have it in my hands. There's no limit. I got it.
There's another contract previously formed for this same group.
Yeah.
The good is reserved.
Well, probably not yet another contract formed, but probably the judge says, well, for some goods, they are still in the shop window, but the salesperson has already promised it to somebody else. So that is why That's the last argument. I'm sorry, I cannot let you have that book. It's the only copy I got, and I've already promised another customer. So that's it. This is so English law with a series of arguments comes to the conclusion: exposure of goods in shop windows is an invitation to trade. It is not an offer. Cannot be an offer. Here are my arguments. Dang, dang, dang. You get a little bit of doctrine just as much as needed. You see, we try to limit the information to the very essentials and to what you need to keep the material still readable from week to week. The newspaper advertisement is an invitation to trade rather than an offer. And then you find, I told you, if you find arguments, highlight them in a different color so you find them easily. Here he has arguments to criticize this. There is business sense in treating, maybe business sense in treating such advertisements and invitations to trade. Because if they were treated as offers, the advertiser might find himself contractually obliged to sell more goods, as you said, the student up there said, than he has in fact owns. But then he says that's not conclusive. And he has a counter argument against this. Okay, so that is English law. We have US law next. Well, is there US contract law? Well, there's not only one US contract law systems, there are many. It is state law. And if you want to know why, read the introduction to US law. Again, it's you can call it superficial, I call it concise. It's very brief, but it explains you some key data. And one key data is they had a discussion on whether there is a US contract law for the 50 states, or if there isn't, you find the background information in the book. So there are, every state has its own contract law. Of course, they look at each other, they compare a lot. It's the same language, the same legal culture. They look across borders. What do the my colleagues in other states of the US do? So students having studied in the US are very much used to working in their case books with cases from all over the United States as a source of inspiration, even if then later you may not be bound in your particular state by this case law, but it's still a source of inspiration. So since the 50 states have their own case law on contract law issues, there is still federal contract law for some issues, so 51 systems, and that got a little bit tricky to have an overview. So what do you teach? What do you learn? You can't do these 50 states every time, so you choose interesting cases, interesting topics, and so on and so on. You teach something, and then some solutions, and then if you work in a particular state, you double check if that is indeed the law in your state. So what the Americans did is, they came to the conclusion at a certain moment, this is just difficult to handle. So we do research, and then we put the results of this research into something that looks like a black letter rule, like a continental codification, and it states what we consider the law is in the majority of states, or what the law should be in the majority of states, and sometimes we make innovations and so on, but we tell you. So this is the restatement of the law. They restate the law. It's not an act. It is not a law. It's a restatement, an academic effort, judges, practitioners, academics working together, writing these restatements. We had 2 semesters ago a colleague from Harvard who is currently writing the restatement on property law. And he told the students, he was here on visit, and he told the students how they do this. So here is the restatement of the law contracts. Second It dates from 1981. Preliminary negotiations, paragraph 26, a manifestation of willingness to enter into a bargain is not an offer if that person to whom it is addressed knows or has reason to know that the person making it does not intend to conclude a bargain until he has made a further manifestation of assent. That couldn't be more general. In a European abstract contract code, couldn't be more general. So it's super, super abstract. But, so you say, well, does that help? Then you get an official comment. And this official comment helps you understand what the law is. Official comment. And the official comment tells you under letter B, advertisements of goods displaying by display, sign, handbill, newspaper, radio, and so on are not ordinarily intended or understood as offers to sell. But can be different. It's, of course, possible to make an offer by an advertisement directed to the general public, but there must ordinarily be some language of commitment, some invitation to take action without further communication. Something where the salesperson commits himself. First come, first served. Come on Saturday morning, 9 o'clock, first come, first served, you get it. This is strong language of commitment. And depending on the state, the court may consider this an offer in the technical sense. So that is possible to make an offer. And you have an example of this. And then, by the way, you get illustrations, you get reporter's notes, a reporter's note, comment B, illustration 1 is supported by many cases. And there, the drafters of the restatement give you leading cases from all over the United States. Different states, and you find the leading case law. So here I gave you one. I took it from a case book on contracts. Supreme Court of Minnesota, Lefkowitz and Great Minneapolis Surplus Store, advertisements as offers. So what had happened there? You have a store that advertised Sunday 9 a.m., some products selling for $89.50. Out they go Saturday, each $1. One black Leibniz-stole, beautiful, worth almost $140, $1. First come, first served. So was that an offer? I've taught comparative law also in the US several times. And in the University of Florida, and my colleague, we were driving around, and we were listening to the radio, and you had an advertisement. Oh, we sell this and that computer. Dang, dang, dang. They give you information, a super price. I asked Joe, was that an offer? And his answer was, no, Thomas, that's just puffing. That's just sales talk. You can't take that seriously. So that was, yeah. So what about this Lefkowitz case? What about this Lefkowitz case?
They said it was an offer because it was so clear and definite and explicit that nothing was open for negotiation, so we could just go to the store. And the price was so clear, so it should be an offer. And if they only want to sell it to women, they could change the offer, but they had to do it before this Lefkowitz went into the store.
Exactly, because what had happened is Lefkowitz was there in time. He went into the shop, said, okay, I buy. And the shopkeeper said, yeah, but there's a house rule. We make this only to women, this offer. And they said, well, you didn't tell us in the advertisement. You didn't say that. And she says, well, the court reaches the conclusion they invited the customer to come. They didn't make any reservation limited to women. Well, there was language of commitment. You get it for this price if you do this and that. And this is an offer. So you have an example of where a common law court takes this advertisement seriously and holds the seller to stick to his word. So that is the Lefkowitz case. And well, when we do comparative law, when we compare in the end and we should we follow this or that example, we may also ask ourselves, are there alternative approaches? Well, you could say, well, here, holding the seller, taking him seriously, saying it is an offer. What are other options? And that is why I put you the note under this case in the material. Another case from New York. A department store had advertised a set of China dishes, a regular price of $280 for $40, and refused to sell. Advertisement was not an offer, the court concluded. So there was probably no language of commitment, or they just do it differently in New York. They don't consider these types of declarations offers. So what is an alternative approach we learn about here? Yes? Yes. You can also say, well, we leave the general contract law as it is, but we create administrative rules on misleading advertisements and sanction misleading advertisements. And that is an example here. New York has a statute, misleading advertisement, $50 you pay to your customer. Not a fine to the state, to the customer. The customer is entitled to a fine of $50 in case of misleading advertisement, and $50 or his actual damage, and $50 without having to prove actual damage. Statute on false advertisement. This is an alternative approach to working with general contract law. Okay, these are the common law jurisdictions on our topic. We will continue after the break with Swiss law and then have a close look at French law. But first, have the break now. Alors, c'est presque écart.
So the class will resume shortly. Thank you. So before you continue your first class on the first chapter, let me inform you that we are organizing each year for CTL students a small party. So there are drinks, there are some snacks, and warm pizza, hot pizza. So you are all welcome to join us. It's for CTL and for the students taking part in the comparative methodology class. So you are all welcome. It will take place on Monday, the 13th of October from 6:30 p.m. to 10 p.m. And it is in room 1170, so just more or less just above us. So on the first floor. Just on the first floor. So above us is the ground floor. Just look at the first floor. And you are welcome, very welcome to join. So, yeah, this is all from me.
It was the
Yes.
assistant for this course last year. Yes, you are cordially invited, very welcome to come. And we have the opportunity to speak a little bit about your experiences in Geneva, questions you may have, and so on and so forth. So it's, okay.
So you have an additional motivation to study well in this class.
Yes,
you have something to look forward to.
Okay.
Thank
you very much, Natalia. So we will come back to our case. And the next jurisdiction was Switzerland. You see there's also a little introduction to Swiss law here in the book. And the question is, how does Swiss law deal with these issues? So the first question is exposure of goods in shop windows in Swiss law. Is this an offer or is it an invitation to treat? So what is the answer for Swiss law? Yes?
That's an offer. According to Article 7, paragraph 3.
Yes. Yes. Switzerland has a code of obligations and a civil code. Why is this so? Why is this so? Switzerland started codification in the 19th century, and as always, the most urgent field that requires legal certainty is commerce. So they wanted clear rules to govern commercial relationships. So the idea was to prepare a code of obligations. And then there was a first code of obligations which came into force in the 1880s. And then the Swiss Code of Confederation received the legislative competence to enact a civil code, so covering all major fields of private law. And so the work on a civil code started. And when the civil code was finally put into force, at the same time, an updated version of the Code of Obligations came into force. So rather than putting both into one single act, as the French did, the Belgians do now, the Germans did, and many others. So we still have these two codes, but the Code of Obligation is in fact considered being the fifth book of the Civil Code. But it starts with a new numbering. So it starts with Article 1 on the conclusion of contracts and so on and so forth. So that is for historic reasons that we have these two codes. And that's it. So yes, the student said, well, a display of goods with an indication of their price is generally considered to be an offer, contrary to what we just found for English and US law. That is Article 7, paragraph 3 of the Code of Obligations. Correct. And you see an example, a leading case, applying this, taking it seriously, the Nussberger case. You have seen there was a good exposed with a price tag in a shop window. Customer comes into the shop, says, I declare I buy this. and he has bought it. He has bought it. So the exposure of the ring with the price was an offer. That is clearly the decision of the Swiss Federal Supreme Court in application of this Article 7, paragraph 3. And then the problem was one of the employees in the shop has omitted, made a little error, omitted a 0 at the end, should have been 10 times the price. But then this is an issue, what do we do with this error? So that is not our first topic here. Okay, so that is the state of the law in Switzerland. What about advertisements? What about advertisements? Are advertisements considered offers under Swiss law? So if you don't see, if you walk down Boulevard Karl Vogt, you see a bike shop on the left, you see exposed with price tag, this is an offer. But if you see the same bike with an interesting price offered in a newspaper, is that also an offer under Swiss law? She says it's not. So which article would you interpret, interpret to reach this conclusion? It's not stated as clearly as for display of goods. Yes?
The seventh article in paragraph 2, like sending of tariffs, price lists, and the like.
Yeah.
Does not constitute an offer.
Yeah, you could use 7 paragraph 2. The sending of tariffs, price lists, and the like, it does not constitute an offer. You can use the a fortiori argument. If even the sending of price lists is not an offer, then advertisement even less. That is even more general, addressed the general public. This is, so you could say, well, I put this under 7 paragraph 2, a fortiori advertisement not. Or others, as you saw in this Luc Thévenot, Franz Vero, Commentaire Roman, they put it under 7 1. Advertisements are not considered to be an offer. Misleading advertisement may prompt sanctions of a different kind, they tell us, under this margin number 5. And then you find a commentary to this. The comment is by François Desmonté. He writes, nevertheless, if we were to contractually bind retailers to respect the letter of the advertisements, as in other countries, in Swiss law, you often find looking across borders, how do the others do, as a source of inspiration. This might well prevent misleading false advertisement. So you find arguments for and against this approach. So for and against this approach. So they also mention in the material that the case where a theater advertised performance in a box outside the theater. Is this an offer, or is this an advertisement and not considered an offer? What about this?
In Swiss law, they only apply that it is a binding offer to goods and merchandise, but not to services.
Yes, yes. We get this information also in the materials on Swiss law. The Federal Supreme Court limited the 7.3 to goods and not to services. The display of goods. So literal interpretation considered to be an offer. The theater advertisement advertises services at the theater performance, and this is not considered an offer. It's an invitation to potential customers or visitors to make themselves an offer. So that is where we are. So that does not, a federal court does not apply it by analogy to services. And you, again, you have arguments on this, criticism on this, and you may use this, because we will end our meeting always with a discussion. Okay, which solutions did we discover, and what are the arguments for and against? And there you may use these arguments you found already in the materials. So next jurisdiction is Germany. German law. Again, I invite you to read a little bit about the background in this introduction that we gave you. It's just, yes, these couple of pages. The German Bürgerliches Gesetzbuch came into force on 1st January 1900. It is the result of hundreds and hundreds of years of study of Roman law. Very systematic, the first civil code using a general part ever, and very well structured, very logic. If they use, in the German civil code, if they use one word, they always use it with the same meaning throughout the whole code. So if they use good faith and they have defined it somewhere in the code, this definition of good faith applies each time they use good faith somewhere. It's just one example among many. So it's very logic, very structured, and yeah. But not necessarily very detailed regarding our topic. As you see, paragraph 145, binding effect of an offer. Any person who proposes to enter into a contract with another is bound by the offer unless he has excluded the binding effect. That is very general wording. A little bit reminds us of the American restatement, very general. So you need case law. So what is the benefit of having a code if the rules are so general? Well, not all rules, you will see that the civil code in Germany, as others, has many very precise rules. But here you get a very general rule. So what's the use of having this? You can say, well, what we then do is we go to case law. We go to case law. We want to know what have the courts decided on this. So we do basically the same work as common lawyers. We go into cases. Do you still see a benefit of having this code? Having general rules like this in this code, yes. Well, it is, yeah, that is the benefit of having a general rule. It gives you leeway, freedom, and so on and so forth. But then you can adjust it. But then why having it at all? If it's that vague, yes.
It enables us to have some kind of structure.
Yeah, that is my very, very strong feeling after years of working in the field of law. It's the code structures our legal material. And if, for example, a lawyer in a codified system looks for a case law, looks for information, he tries to identify the rule that is as close as can be to the question he's researching, and then you go to a commentary. In many jurisdictions, we use commentaries. You go to a commentary, and you find the case law easily, quickly. Case law, you identify the provision, you go to this commentary on this provision, and then it's again structured, and you find your way to your relevant case law. It's not just, okay, I have a legal question, and here are thousands and thousands of cases, and I need to find somehow my way. So the code structures your legal material. And I can tell you, you will see throughout this class that we use material from many different jurisdictions. And sometimes you may ask yourself, how did you do this? The answer is, our starting point was, first, do they have a code? Second, where do I find a provision as close as I can get to this particular question? And then, is there a commentary? And then we go to the commentary. And this is sometimes, I researched for an article, I researched a precise question. I did in 5 days, before I was employed here, I wanted to write an article on this. I took 5 days in our library, and within 3 days, I had information on this precise question on a whole lot of jurisdictions, because they have codified it. And I could copy commentaries from the, on these different provisions once I identified them. And then you get amazingly quick information on many legal systems, which is a different topic if you don't have any legislation on it and you say, well, I switch my computer on and then I move from one case to the next and doctrine and here and here and here and here. Well, the restatement of the law is another, is helping, but then they update it only every, well, 50 years or 30 years, so it's not up to date necessarily. So basically, as you said, it structures our material, it helps doing the research. So if you go to commentary on 145 BGB, you find the cases that we gave you here. So what is the attitude in German law? Binding effect of an offer. A person who proposes to enter into a contract with another is bound by the offer. Yes, is bound by the offer. So did the theater make, in this first case, Imperial Court of Justice, in this first case, did they make an offer in the technical sense? Did they make an offer? To make the scenario easier, it was a bit more complicated in real life. But let's say you see a piece of a theater piece advertised. The seat is still available. You walk into the cash station and say, I want this seat, here's my money. Have you formed the contract? The case was a bit more difficult. We gave you a footnote explaining, but the court was quite clear regarding our question. Is that an offer? Yes. It's an invitation to treat only. It's an invitation to treat only. And which argument does the court give us here? You saw the English court, they cannot hide behind anything. They have to give you, we decide this. Case law, here are our reasons. So what is the answer of the German court in this case? And I can tell you, we have done quite a bit of research that there must be something more precise than that. There isn't. So, but they all agree. What is the argument of the German court? Yes. Yes, that is the result. It's not an offer, it's an invitation to treat. But why? Why? Yes.
It depends on the real will.
Yes. It depends on the intention of the person making the declaration. And then you interpret this intention from the perspective of the person who receives the declaration. And then the court says, that's all they give us. They say, well, it is obviously the intention of the operator, and it is indeed obvious to the public in this situation that this is simply a non-binding declaration of readiness to contract, such as, and then they extend this to other situations, such as one finds another public announcements or in the circulation of price lists. So that's it. It's obvious. If you write this in a research paper, you fail. You say, hey, nothing is obvious in law. Look at Switzerland, it's not obvious. That's not a reason. So they sometimes hide behind a legal provision, 145, and then everything else is obvious. 145. So that is a bit the risk of having a code. You say, well, the provision means this, and here is and no further arguments. You will see during our course German decisions which are much more precise, giving reasoning like English or US courts, but not this one. So this is the first precedent. And this is basically, we all understand, we all know that this is not intended to be a binding offer. And then we have a case from 1980, a Federal Supreme Court of Justice. And do we find more reasoning there? And this is about exposure in a shop window in this case. And the court reasons, the prevailing view is that the display of goods in a window is not an offer within the meaning of 145, even if the price is indicated. On the contrary, it invites the customer to make an offer. So what is the argument here? The prevailing view, die herrschende Meinung. This is not an argument as to substance. It's not telling us why this is so, that they balanced the interest of the parties and so on and so forth. It's just the prevailing view. So again, it's amazing. We had a doctoral student once who researched the method of reasoning, particularly here in German law. And she said, well, some very, very important innovations in German case law had a very, very thin reasoning. It was just like this. And then it was there. The new idea was circulating, was there, and then it was applied. And then, as we apply in constant case law, you had one or two previous decisions, and then it's there. No further argument hiding behind a codal provision. Well, again, that's not always the case. So what about, what about, this is display of goods. What about advertisements? What about advertisements? The same result. So advertisements, display of goods, invitations to treat only. Okay, now we turn to France. Do you have any questions regarding German law here? It's basically the same idea as in the common law jurisdictions. Both are just invitations to treat. So France, our next jurisdiction. Again, you have the introduction to France, and you have extracts of the French Civil Code, which dates from 1804. 1804, but the contract law, the general contract law, was reformed in 2016, came into force. They also wanted to reform the tort law, but this is still on the agenda. That won't happen soon. So 2016, the new rules on contract law. 1113, a contract is formed by an offer and acceptance expressing the party's willingness to be bound. Such willingness may be expressed in words or clearly implied from the relevant party's conduct. Okay, an offer, whether it is made to a specific person or the world at large. So you can make an offer to the world at large. First information. So the fact that an advertisement is addressed to anybody, it doesn't prevent it from being an offer. And yes. And then a world at large must contain all the essential elements, of course, of the proposed contract and indicates the willingness of the offerer to be bound in case of acceptance. The Germans said, well, an offer made to the public in an advertisement, there's no intention to be bound. That's not an offer. In French law, well, what you need then is, again, case law. You need case law. And you need to go to the decisions of the Cour de Cassation, which is the highest court of the country in civil law issues. So the Cour de Cassation. I checked with my French colleagues of this, if this case is still good case, good law after the 2016 reform, and everybody agrees it still is. It still is. Malscon contre Braquet. Some students had doubts when they saw this Article 1114, because the last sentence says, failing this, it is only an invitation to treat. They say, well, in case of doubt, it's an invitation to treat. But then I don't think today in this situation the courts would have doubts. They would say, well, we have this case law. This is still good law. So you have this Malscon contre Braquet case. How many sentences do you find in this case? You have a court decision by the Cour de Cassation, which is, again, the last instance in private law issues. How many sentences? In how many sentences does the court phrase its judgment? One single sentence. The sentence goes, the court, and then you jump to the bottom, decides, it's still the same sentence. The court decides to quash and annul the decision of the Court of Appeal in Nancy, given on 24th November 1966, and hereby refers the case back to the Court of Appeal in Reims for reconsideration. Full stop. This is one single sentence. One single sentence. And then the court inserts all its considerations into this one single sentence. So that is the way the Cour de Cassation reasoned from 1804 till 2019. 1804, when the French Civil Code came into force, till 2019. We will probably start reading this decision first, and then I'll give you some information. We discuss a little bit why this style, why this short style, concise style, limiting to the very essentials. What did you understand? How did you understand this case? Is an advertisement in French, the facts, in fact, the facts you saw was, again, I tell you this time, but next time you, from case 2 onwards, I'm not that detailed. One piece of land was offered for a stated price in a newspaper, a piece of land in a newspaper offered or advertised. It was still available. A person interested, having the money, declared acceptance. I accept your offer. And the salesperson did not want to sell anymore, didn't want to sell to that person. So the question was a contract formed in this situation? Was a contract formed or wasn't? Who thinks that a contract was formed? Who thinks that no contract was formed? Okay, we do the same exercise with no abstentions, please. Okay, you hopefully have read this or... So, who thinks a contract was formed? Who thinks no contract was formed? This is almost 50-50. 50-50. Okay. I admit this style is super difficult to understand, in particular if you're not used to it. As far as I've seen, the French students got it right, but I had French students who got it wrong from the same university before. So I suggest we read this decision together and we try to identify what this is all about. So it's one single sentence. The court, on the single ground of appeal, whereas an offer made to the public at large binds the offerer vis-à-vis the first person who accepts it in the same way as an offer made to a specific person. Whereas it results from the, by the way, when I sent the manuscript to the publisher of the first edition, they sent me an email and said, well, can't you furnish us, can't you send us a decent translation of this French decision? That is very weird. And I told them, yes. And we leave it exactly that way because that's how they draft their judgments. We won't correct the French, the style of French judgments. We want the reader to understand that is how they frame their decisions. So again, third line, whereas it results from the partially upheld decision that Malscombe, having become aware of an advertisement proposing the sale of a given piece of land for 25,000 francs in the newspaper Ardennais on 23rd May 1961, made known to Braquet, the owner, that he accepted the letter's offer, that, however, Braquet claimed not to be bound by the offer. What is this? What is this?
The arguments by the parties.
Well, a little bit it is also the arguments of the parties. But what it is basically? The facts. The court tells you what has happened. What has happened? The court tells you a person, Malscombe, having become aware of an advertisement proposing the sale of a given piece of land for 25,000 francs. That's how the facts. In the newspaper, he contacted Braquet. The owner told him he accepted the letter's offer, and Braquet claimed, I'm not bound by this, I don't sell that to you. That is the facts. So there is no separate section on facts. It's all inserted within this single sentence. I continue the reading. Whereas the ground for dismissal of Malscombe's claim for an order requiring the sale to be completed, as set out in the contested judgment, state that an offer, quote, an offer made in a newspaper for the sale of an asset which can only be purchased by one person cannot be equated with an offer made to a specific person. It constitutes merely an invitation to treat addressed to potential purchasers and cannot therefore bind the person by whom it is made vis-à-vis a person who accepts it. What is this? Not the French. You are specialists on this. You're French. Yes. What about the others? What is this? I suppose that those who raised their hands, there was no contract formed, thought of this. That is not a binding offer, no contract formed. Yes?
I was thinking this is the lower court's reasoning.
This is the lower court's reasoning, exactly. This is the Court of Appeal's reasoning. That was the Court of Appeal in Nancy. Whereas the grounds for dismissal of Malscombe's claim for an order requiring the sale to be completed, as set out in the contested judgment. So they tell you what the contested judgment had decided. And which court was that? You see, Court of Appeal in Nancy. It was the judgment, the previous judgment was already an appellate decision. Court of Appeal in Nancy. So the court says, they quote the Court of Appeal of Nancy, an offer made in a newspaper for the sale of an asset which can only be purchased by one person. They say, well, there's only one piece of land. Can only be purchased by one person. This cannot be equated with an offer made to a specific person. It constitutes merely an invitation to treat, addressed to potential purchasers, cannot therefore bind the person who makes it. Okay, that was the Cour d'appel de Nancy. That was the contested judgment. Whereas, in making that general ruling, despite its finding that Braquet, upon receiving notice of the acceptance, had stated that the farm had not been sold, has not been sold yet, and without mentioning any factor which could have prompted it to infer that the advertisement constituted merely an invitation to enter into negotiations, or that Bracker's offer was subject to any qualifications, the Court of Appeal failed to establish any legal basis for its decision. So what is this? The reasoning of the Cour de Cassation. The Cour de Cassation says basically, well, why was that not an offer? He didn't make any reservations, any qualifications, the farm was not sold yet. Why shouldn't this be considered as an offer? They got it wrong, the Court of Appeal. We quash the decision and we send it back to another Court of Appeal. Okay, so the sentence ends. The court decides, for the reasons given, to quash and annul the decision of the Court of Appeal in Nancy, and hereby refers it to another Court of Appeal in Reims for reconsideration. Of course, expecting that they follow the Cour de Cassation's reasoning, which is not guaranteed, but it's usually the case. So, the Cour de Cassation decides this advertisement with the price of a piece of land, which is still there, is an offer to anybody who is able to pay the required price. So they take it seriously. This is an offer. Why this style? Which is the opposite end when we compare it to the English decision. I so reluctantly confess, I had so many doubts. In the ordinary meaning, it is clearly an offer. I have a headache having decided the contract, but I still do because, and so forth. They tell you everything. Here, they don't tell you anything. Not the, no doubt, no name of the judges. It is just as if it couldn't be otherwise. Why? Why is this so?
Because of the regulation, that the judges are only considered to be the mouth of the law?
Yes. This is because of legal history. Legal history. In French, before the French Revolution, the courts were particularly conservative, and even more conservative often than the legislator. So when the French Revolution, 1789, tried to overturn all this system, and under the influence and presence of Napoleon, they drafted the civil code, they drafted the code, and they wanted to limit the power of the courts to divert from the intention of the legislator. So they wanted to limit the power of the courts. The first idea was no power for interpretation. But then there's a rule in the French Civil Code which says the court cannot deny a judgment with the argument that the law is not clear. So they need to interpret the code. So what they did was they created un tribunal de cassation. So an institution that was meant to control the courts. So you could appeal a decision of the courts, the last decision here, Cour d'appel, you could appeal it and ask for control by this institution, which was itself not considered to be a court, not part of the French court system. It was an institution that was meant to control the courts. And this is why in any other jurisdiction, you would ask yourself, not influenced by French law, you would ask yourself, well, this is a legal question. This is just a legal question. So the last instance court can decide this itself. But not so in French law. They quash the interpretation of the previous court, and rather than deciding themselves, they refer it back to another court. la Cour d'appel de Reims. Because to decide a case, you need to be a court. And in the first years, the Cour de Cassation, what is now the Cour de Cassation, was not considered a court. So this is why they either confirm, then it's the end of the story, or they quash, annul the judgment and send it back for reconsideration, because they can't do it themselves. Then, quickly after the French Revolution, when the system came into force, this institution turned into a law court. Cour de Cassation. It is a law court now, the court of last instance. But for tradition, it is still limited to confirm or quash on issues of law. Okay, this is the first thing. And the second is, because they wanted to abolish any discretion for the courts, the Cour de Cassation used a style which avoids any appearance of discretion. They decide as if nothing else is possible under the law, as if they are la bouche de la loi, the mouth of the law. So you put, here's the law machine, you put the scenario in, it chucks, comes out, a logic decision can't be different. No doubts, no, despite reluctantly, I confess, and so on and so forth. Nothing like this. It looks like can't be different. They don't even quote many legal, nothing here. No legal rule quoted, no previous case law quoted, no opinion in legal doctrine quoted, nothing. They quote just nothing. It's just, here it is, our decision. And since this is hard stuff to understand, even for lawyers, but much more for non-professionals in law, you get case notes. You get case notes under these. In previous times, I don't know if that's still. In previous times, sometimes even the judges wrote a case note on a case they had decided, they had participated in the decision. So they write a case note explaining the decision. Or it's written by a specialist, by a law professor specializing in this field. They write their case notes. They explain to the general public where to situate this case in the development of the law. So that is the style. In times, at the end of last century, in times when a European private law developed and we looked across borders for inspiration and so on and so forth, courts started quoting courts of foreign countries more and more. And the French made the experience, they don't quote us. We don't participate in this discussion because they don't understand us abroad. So we should probably reconsider our style. We should probably change it. And they changed it. They changed it in 2019. The then president of the Cour de Cassation issued new rules. They changed their style and said we need to be easier to understand. We need to be clearer in order to have an impact. First of all, be understood by our own citizens, and second, have an impact in the cross-border legal discussions and so on and so forth, because they simply ignore it so far. We have English court decisions where the court says on an interpretation of the CISG, there's a French case, they tell us it's a leading case, but we don't understand it. Leave it aside. And that was, that was not very much appreciated, of course, by French judges. So they changed their style and they get more readable. Our cases in the book are all the key decisions on key issues of French contract law. This is all still old style because they don't decide on this today because it's already has been decided. So that is why you have to struggle a little bit with this style. We'll read For the second case, we also read the whole French decision, and from case 3 onwards, you do it yourself. And you will see you're trained in this. You will understand that. So this is the reason for this particular style. So if we do comparative law, it is not only about content, it is about style, it's about many aspects. I think our time is over, which is not a problem. We have not finished this case, but we didn't want to finish it today. I told you we take 2 weeks for this. So we'll finish it next week, next Friday from 10 to 12. So finish your readings. Use, it's much less now. Try to read the introductions that you haven't read yet, and so on and so forth. See you next week. Thank you. Try with others sometimes. And if you get a thank you. told the court. They told the I think it's, they told the court that it was not. Ah, you mean? Yeah. Okay, I understand.
I mean, I understand the court is not giving any justifications. I think the technical reason you offer.
Yeah, okay. Yeah, okay. Well, but that was intended. You mean that was a new offer? Yeah.
The buyer is thinking that he's doing an acceptance, but technically he can classify it as an offer.
And then,
And the answer
has
is
he?
saying that, okay, the land is not sold yet.
But at the same time, he said, no, the land is not sold, but I don't sell it to you. Because that, he refused to accept the contract, but said, yeah, the land is not sold, but I don't sell it to you. Must have been. No, there are no details at all. Yes, because otherwise it wouldn't make sense. If he said, well, the land is not sold, and by that he made a new offer, he must have refused to sell for this person.